Recently, a subscriber emailed me a question having to do with the need to address egregious judicial actions more quickly than through an appeal. I'll tell you what he said and give you my response in just a moment. Here's what we're talking about today. Here's what my subscriber said. This is him talking. My thesis then was that there were times when judicial acts are so egregious and improper that perhaps intervention is required immediately, not in the fullness of time. I'd like to invite your attention to the case of Commonwealth of Massachusetts versus Kelsey Fitz Simmons as being just such a case. In short, Ms. Fitz Simmons was shot by a coworker who was serving process on her. And for background, Fitz Simmons was a police officer herself, and there's some question about how much on the up and up this whole thing is. She spent more than a month in the hospital being treated for her injuries. The judge released her to home confinement with certain conditions. The defense moved to delay installation of an ankle monitor until after scheduled surgery. The court denied the request, and on information and belief, the surgery never happened. The court released her to home confinement with random alcohol screening. Over the course of the day, she completed the required alcohol testing, but at the expense of immense pain, not only at the time, but hours afterward. The defense moved to have the method of testing changed. In response, after some court proceedings and motion practice, the court ordered her remanded back to custody. The remand order set forth statements which were plainly false as to facts observed by the court during the hearing and set forth interpretations of law which were plainly contrary to the applicable law. At that point, he linked to another law channel that's covering this. That's Melanie Little. And I recommend, if you're interested in that case, that you go look her up. She does a very good job. He continued, I submit this is an example of a case where immediate intervention is not only merited but necessary. That the court took active steps to create conditions where an individual could not receive necessary medical care could be seen as a tort under common law, except judges are usually immune from that. A jailer has a duty to care for a prisoner under the Eighth Amendment of the U.S. Constitution. That's right. He can't make the conditions of confinement equate to cruel or unusual punishment. And of course, having not been convicted of anything at this point, absolutely they can't do that. So I can't speak to that particular case. As I said during Karen Reed's trial, Massachusetts generally treats female defendants in big cases like dirt. I'm not sure why there is such judicial hostility toward women in Massachusetts. It's not like we don't all have mothers, after all. But I explained to him, and I'm going to explain to you here in just a second, how, if this was my case, how I would address this kind of thing. So today, for that reason, we're diving into extraordinary writs. These are special remedies used in both federal and state courts when an ordinary appeal will not do. These writs, mandamus and prohibition, are not handed out like candy. They're difficult to obtain, they're rare. They're only issued when there's no other adequate remedy at law to protect the party's rights. I think in Kelsey Fitzsimmons' case, the denial of surgical care to a defendant is exactly the kind of issue that should be addressed in this way. Failure to have proper surgery at the right time can lead to long-term disability. And in addition to that, the idea that you might have to break something or re-break something in order to fix it, that also is not really good medical care. So the first writ that I want to talk about is called the writ of mandamus. Now, the writ has a very rich history, particularly in the common law courts of England. As I've said numerous times on here, we got all of our common law from England, and the writs of mandamus and the writs of prohibition both came to us from England when we separated from them. So The writ of mandamus is essentially a court order telling a lower court, or sometimes a government official, to perform a duty that is required by law. Now, it has to be a duty that is required by law. So, for example, if a party submits an election petition to have it be put on the ballot and it is in the proper form and it has the proper number of signatures, then the Secretary of State or whoever controls that does not have the discretion to say, "No, I'm not doing that." So you could get a writ of mandamus in that situation to compel that government actor to do what is required of him by the law, because it's not discretionary. However, there are an awful lot of acts that are required to be performed by government officials that aren't discretionary. For example, the issuance of a concealed carry permit. Even though someone might have a clean record, maybe there's just some reason why the court, or in that case, the government official, doesn't believe they should have a permit. Well, first of all, there is an appeal mechanism for that particular problem. You can always appeal the denial of a concealed carry permit. What you can't do is you can't file a writ because there is that particular remedy. Plus, it is a discretionary act. You can appeal because there's an abuse of discretion, but you can't get a writ for what amounts to a basic abuse of the official's discretion in that case. The writ of mandamus is about compelling action where the law leaves no room for choice. As I said earlier, for example, if a court clerk refuses to file a pleading that must be accepted, mandamus can force compliance with that mandate. Obviously, mandate and mandamus have a lot going together there. If there is a mandatory duty under the law to do a particular act, and if there is no other way to get that act compelled, then a writ of mandamus would be the right approach. In federal courts, the All Writs Act gives appellate courts the power to issue mandamus, but the Supreme Court has made it clear that it's only appropriate in exceptional circumstances. Under federal law, the key elements are the petitioner must have no other adequate means to obtain relief. Also, the right to relief must be clear and indisputable. And thirdly, the issuing court must be satisfied that mandamus is the appropriate remedy under the law and under the circumstances at issue. State courts also recognize the writ of mandamus, though standards vary from jurisdiction to jurisdiction. Some state courts use it more freely to control lower courts or officials, while others, like federal courts, restrict it to extraordinary situations. Across jurisdictions, though, there is a common thread. There has to be no other adequate legal remedy that could suffice. Here, in the Fitz Simmons case, it seems obvious to me that she has an Eighth Amendment right to medical care. She's an accused, she's not been convicted. Denying her that care is both an abuse of judicial discretion as well as a violation of her constitutional rights. Mandamus might very well be the appropriate remedy in that case. But there is another writ we need to talk about since we're talking about extraordinary writs, and that is the writ of prohibition. Now, unlike the writ of mandamus, instead of compelling action, the writ of prohibition essentially stops action or forecloses action. That might be a better way to say it. And in some cases, because there is some overlap with these writs, lawyers will often file a writ of mandamus or, in the alternative, a writ of prohibition, basically saying to the appellate court, hey, this is screwed up. No matter what writ you use to fix this, it's got to be fixed, which can sometimes be a very effective way to proceed in this situation. The writ of prohibition, as I said, is the mirror image of mandamus. Instead of compelling action, it stops a lower court from acting outside its jurisdiction or exceeding its lawful authority. Several years ago in Missouri, and in fact from law school up until that time, the rule had always been that prohibition stopped the court from exceeding its jurisdiction. But in that year, the court decided that because courts have jurisdiction to make errors, that they couldn't say that it was a jurisdictional issue. So they say now that when a court has exceeded its lawful authority, it's a distinction without a difference, but that's the general rule. Think of it as a judicial red light telling a lower court you can't go forward. In federal court, prohibition is also rare, but available under the All Writs Act as well. For example, if a district court tries to hear a case clearly outside its jurisdiction, for example, one that contains only state law issues and is between citizens of the same state, an appellate court could come in and prohibit the proceedings through a writ of prohibition. Just like mandamus, the party has to show there is no other effective remedy, such as waiting to appeal after the final judgment. The way that I have seen prohibition work, and it works very well in this instance, and probably makes it a little bit easier to understand, is when you have a privilege issue. Let's suppose that a guy, Mr. A, is charged with fraud, and he had consulted his lawyer before he engaged in the conduct, and he now wants to say that there is some kind of blessing for his conduct because he sought legal advice. And in that situation, he's making the legal advice of the lawyer relevant in his case, and the lawyer would really have no basis whatsoever to contest a request for discovery of that. However, if he had represented him in a DUI case 2 or 3 years previously, or he had represented him in a divorce 1 or 2 years previously, the information shared during those instances is not going to be relevant. And if the court had said you have to turn over your entire file, all cases, all situations, that would be outside the jurisdiction of the court or outside the lawful authority of the court, because in that instance, only a limited subset of what the lawyer offered as advice would be relevant in that criminal fraud trial. So, in that situation, what the lawyer does is files a writ of prohibition. And some states make prohibition more available than mandamus, but the extraordinary nature of the writ remains the same. It is not a substitute for appeal. In fact, the common element between prohibition and mandamus, the single most important feature of both of those writs, is the requirement that no other adequate remedy at law exists. If a party can wait and appeal after the case concludes, the higher court will almost always deny the writ. It's only where you have a situation like privilege, where if once the privilege is lost, you can't put that genie back in the bottle. All these writs are designed for emergencies, situations where waiting, for example, disclosing the privileged material, would cause irreparable harm or allow a lower court to act completely outside of its authority. Now, I want to talk a little bit about writ procedure. Filing a writ does not guarantee issuance of the writ. What filing the writ does is it essentially stays the conduct of anything in the case where the writ has been filed until the appellate court speaks. In the last case that I handled in the appellate nature, the Cockerham case, the individuals on the other side of that case, the insurance company, filed a writ. It went to the Eastern District Court of Appeals, and it stayed there for 3 days. Before I could get my answer to that writ on file, the court denied the writ. So here's the normal procedure. You file a petition for a writ of prohibition or mandamus. It gets served on the other side, the opposing party, as well as the judge. You have to get a copy to the judge. And then, having done so, you wait for the Court of Appeals to do one of two things. Either they deny the writ outright, which sometimes happens, or they ask the other side for their comments on whether a writ should issue. And of course, usually their comments are, heck no, the writ shouldn't issue. The judge is doing what I want him to do. But either way, they have to file a response. They file that response. The court weighs their response, and then if they feel like it's a good thing, they will issue what's called a preliminary writ. In other words, it's preliminary relief until such time as the court can take up the matter and decide it completely. At that point, they will ask for briefing, and normally the person who wants the relief will file a brief, and just like any other appellate court brief, and the party opposing will file a brief. Then the petitioner files a reply brief. The briefing is done. The court will then take the matter up, set it for oral argument, hear the case, and decide the issue. If it decides favorably to the petitioner, it issues a permanent writ of prohibition or mandamus. And if it decides against the party, then the preliminary writ is dissolved as being improvidently entered. Now, some courts, like the Western District of Missouri, are very fast, and you might get an opinion within a week. You might even get an opinion within the same week where you argue the case. Sometimes it takes longer than that. Sometimes it takes several months. I've seen situations where it's taken 9 months to get a relief. But when it does come down, you have the answer. And either you get the relief that you've requested, the court is confined within its jurisdiction, or ordered to do something, or you're back at square one and all you've done is delay for however long that is. Here's the takeaway. Writs of mandamus compel action, writs of prohibition restrain it. Both are extraordinary. Both demand that the petitioner show that there is no effective appellate remedy that they can use, and both are sparingly used in both the federal and state court systems. They're the legal system's fire alarms. They're pulled only when ordinary processes won't protect the rule of law. Now, you might ask, why doesn't the lawyer in the Fitz Simmons case use this? Well, it could be that Massachusetts law is not favorable on this issue. Massachusetts law is not favorable on a lot of issues, and that might very well be one of them. Some states issue these writs so irregularly that they're nearly invisible to the bar. People learn about them in remedies in law school, and then they never have an opportunity to file one. Or it could be that the lawyer doesn't have the appellate training necessary to understand how to file a writ. Or he believes that some of this can be cured by appeal, or perhaps by a civil rights lawsuit against the restraining individual, in this case, the jailer. I don't know. I don't fault him for not filing one because A, I don't know him, and B, I have not researched the law in Massachusetts on this issue. And that's important because in order for me to say, well, he ought to file a writ, I would have to know that a writ would actually work and that it would be something that would fix the problem. And I don't know that that's the case. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee, anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.